This is Choosing the Right Divorce Process for You, presented by South Jersey Divorce Solutions. My name is Melissa Fikak, and I am the founder and owner of South Jersey Divorce Solutions, located in Merchantville, New Jersey. You will find that one of the most important decisions that you will make in your divorce is how you divorce. What do we mean by that? Well, there are different ways that you can divorce. One is mediation, the second is collaborative divorce, the third is negotiated settlement, and the fourth is litigation. You may ask yourself, well, aren't all divorces completed through the court system? Well, that is very true. Once you have come to a settlement, or if you haven't come to a settlement and you need to litigate your divorce, there will need to be a complaint filed with the court. But spouses are not required to litigate. In the majority of divorces, and what that means is here in New Jersey, approximately 98% settle, meaning that the spouses have come to an agreement on all their outstanding issues and do not require the assistance of a court in having a trial. In mediated and collaborative divorces, a complaint for divorce is not usually filed until after there is an agreement made between the spouses. The first process we will talk about is mediation. What is mediation? Well, mediation simply is a process where a trained neutral person uses specialized communication and negotiation techniques to assist a couple to come to a resolution. Mediation is not about reconciling the relationship. Instead, it is a process that helps the spouses to dissolve their marriage without destroying their lives. There are non-adversarial techniques used in developing your mutual marital settlement agreement. Spouses may mediate with or without the assistance of attorneys. Mediation is a confidential process. This means that spouses have the ability to speak freely, to put all their cards out on the table, and to disclose everything that is necessary to make a decision in their agreement without the fear of that information being made public. Why mediation? Couples who divorce through mediation report that they have a greater level of satisfaction than those couples who divorce through litigation. Parents often find that by going through the mediation process, they have the skills to better co-parent their children. Clients often find that the outcomes are more satisfactory because it's an outcome that they have made a choice in. It's controlled by them as opposed to having an attorney or an arbiter making those decisions for them. Mediation promotes creativity and problem solving in designing resolutions that work best for the spouse and family. And compared to other divorce processes, mediation tends to be more cost efficient, meaning a lower in cost. Who can mediate? Anyone who is willing to work together towards a mutually beneficial resolution can mediate. Those parents who want to be able to continue to raise their children cooperatively tend to find that mediation works for them. And spouses who are both committed to a process of being open, of disclosing all necessary information to both the mediator and to their spouse, as well as they are open to listening to the other person, what they have to say. In those situations, they find that mediation works for them. Mediation isn't always the right fit for every couple. If there is a history of domestic violence, if there is a great amount of mistrust between the spouses, if there is one or both spouses attempting to control or delay the divorce process, or if there is a spouse who's committed to litigating and unwilling to negotiate, then those cases will not be successful in mediation. The next process we will discuss is collaborative divorce. Collaborative divorce is a private process. where couples resolve their differences with the use of collaboratively trained attorneys using negotiation and specialized communication techniques. In the collaborative divorce, the attorneys will work using a team approach where they use non-adversarial tactics to advocate for the benefit of their respective clients. One of the benefits of the collaborative process is that other team members can be brought into the process to assist the couple to coming to an agreement. Who makes up the collaborative team? Well, at a minimum, each spouse will have his or her own collaboratively trained attorney to assist them. In most cases, we also utilize the services of a divorce coach. A divorce coach is a mental health professional who works with the couple in addressing the emotional issues. The coach also serves as a facilitator during meetings and helps to lessen the conflict between the spouses and their respective attorneys during the process. This allows everyone to keep focused on getting a resolution, which is the task at hand. In cases where there's parenting issues, a child specialist may be used, or the coach may also act as a child specialist to assist parents in coming up with a parenting plan. Financial neutrals can be utilized to assist couples with such things as spending plans, the distribution of assets and debts, or the valuations of complex assets, such as businesses. In some instances, one spouse may feel that they need some additional assistance to give them some insight in helping them making decisions. In those cases, they may have a financial advisor to specifically assist them in coming up with spending plans, retirement plans, and looking at what are their best interests with regards to coming up to a resolution. We may also utilize the services of professionals such as mortgage professionals or realtors to address things like what happens to the marital home. Why should you select collaborative divorce over mediation? Well, not every couple is suited for collaborative divorce, and not every couple is suited for mediation. In those cases where a spouse feels that they need to have an attorney to assist them during the process, they may find that collaborative works for them. Couples who are struggling with coming up with a parenting plan find that using a coach or a child specialist makes that process much easier. If there's a lot of emotions that are attached to that divorce, the couples find that they benefit from having a coach to assist them through those difficult issues. If there are complex financial issues that may be above and beyond the knowledge base of the mediator, that is somebody who can benefit from having a collaborative divorce. And those couples who feel that they just need a little bit more support than the mediation process provides to them, but they are committed to not go through litigation. All of those are situations where they can benefit through a collaborative divorce. Collaborative divorce tends to cost more than mediation, but that's not always the case. Nobody can predict exactly how much your divorce is going to cost. But mediation does use less professionals, and that helps to reduce the cost. However, in a collaborative divorce, it tends to be less expensive than a litigated one. And the reason why is in the collaborative process, we're using professionals who are best suited to address an issue to help a couple to resolve their differences. For example, financial neutral will be utilized to assist with spending plans. A child specialist or coach would be used to address issues regarding custody. This results in a more effective negotiations and does lower the cost for the spouses as a whole. Who cannot collaborate? Like mediation, not every couple can divorce collaboratively. People who cannot collaborate are those where, again, there's a history of domestic violence or abuse. In instances where there is one spouse who's unwilling to participate or cooperate in the divorce process. If there is pending litigation, the couple cannot collaborate unless they are willing to withdraw that litigation. And also in situations where one or both spouses are unwilling to make full disclosures of assets, debts, and other information that is pertinent in coming to a final resolution. In deciding between collaborative process and mediation, couples should talk to one another to determine what they believe is the right process for them and their family. Sometimes what couples will do is they will meet with a divorce coach prior to choosing which process, and that divorce coach will assist them in looking at all of their options and go over any questions they have so they can make an informed decision as to what process will be right for them. There are coaches who sometimes will meet with couples for free or low cost to just go over the divorce process information. Since there are similarities in both mediation and collaborative divorce, it's not uncommon for a couple to start using one process and they then agree to switch to another one. There is also the possibility of using a mediator in a collaborative case where they have an impasse, or having collaborative attorneys assist spouses during a mediation. There is an important distinction with collaborative divorce. Collaborative divorce cases begin with the signing of a participation agreement. This agreement sets forth the roles of all the participants in the process and helps to protect the spouses by maintaining privacy and confidentiality. A key provision of this agreement is also that the parties acknowledge that they will not litigate or go to court. If either or both of the parties determine that they wish to leave the collaborative process and commence with litigation, all of the professionals, meaning the attorneys, financial neutrals, and coaches, will no longer be able to assist the spouses. Each spouse would need to find new attorneys to assist them in finalizing their divorce. This is not true in other divorce processes such as mediation. It should be noted that just because couples leave the collaborative process and they have to start with new attorneys doesn't mean that they start from scratch. In many instances, couples will just start from what issues they have not settled, but they will keep intact the settlement that they do have on the other issues. Negotiated settlement is the next process we will discuss. What is a negotiated settlement? Negotiated settlements are where the couple resolves their differences and enter into an agreement. Some couples are able to resolve their differences on their own, and then they hire an attorney to draft the marital settlement agreement and complaint for divorce that will be filed with the court. This can sometimes be referred to as a kitchen table divorce and can be very cost effective. Other couples use attorneys to assist in actually negotiating a final settlement, and then the counsel will share in drafting the necessary documents to go through the court system, thereby allowing the cost to be distributed between the spouses. The benefits of a negotiated settlement is that it can be very cost effective. It also allows the spouses to have greater control in the outcome and the agreement than they would in litigation. Spouses can move at their own pace and are not bound by court timelines. Going through the court system, divorces can take a year or they could take a couple of years. It's really dependent upon not only the spouses and their abilities to get information as necessary, but also on the court's time and what is the court's availability. It's not uncommon for trials to be scheduled a couple of years after a complaint is filed. Mediation, collaborative divorce, and negotiated settlement all tend to have outcomes with greater satisfaction by the spouses. Spouses who are satisfied with a final agreement are less likely to return to court afterwards to fight out any of the issues that they have, and they're more likely to abide by the agreement that they've come to. What are some of the possible pitfalls in a negotiated settlement? If both of the spouses are unrepresented, they may not address all the issues that they should in their final agreement. This may lead to problems later on, and that may require an attorney to correct any deficiencies that they have, or there may be issues that are unable to be corrected later on or have a very costly resolution. If one spouse is unrepresented, there is a tendency that that spouse will feel that the decision was not very favorable to them, that they were pressured into entering into the agreement, that they feel that they were seriously disadvantaged. That would then lead to an inequitable result, and that spouse would tend to be less likely to abide by the agreement that was reached by the parties. If there's a pleading pending in court, spouses may feel the pressure to enter into an agreement to avoid having a decision made by the judge. This can then lead to feelings of being forced into entering into their agreement, and again, they may not be willing to abide by that agreement. The last process we're going to talk about is divorce litigation. What is exactly litigation? Litigation simply is the divorce process that most people are familiar with. This is the one where somebody files a complaint through the courts, and the courts then assist the couple in making decisions for them in those situations where they are unable to come to an agreement on their own. Attorneys often use adversarial tactics to gain a decision from a judge or to pressure the other spouse into making a settlement. Even in litigated cases, a very small percentage end with a trial. Why would a couple want to litigate? If there's a history of domestic violence, most couples are therefore only have the option of litigation. If there's a severe inequity in power in the relationship between the spouses, or if there's a severe amount of lack of trust, in those situations, it's more likely that the couple will end up going to court. If there's also an unwillingness to cooperate or participate in an alternative process, or there's a spouse who's attempting to prevent another process from occurring or to participate in, that is going to end result in having the couple go to litigation. What are some of the concerns with litigation? One of the biggest concerns can be cost. Litigation tends to be the most expensive way for clients to divorce. There's also the lack of control in the outcome. Spouses tend to have the least amount of control in the litigation process because they're allowing a judge or someone else to make decisions for them. Because there is a lack of control, there also tends to be a lack of satisfaction in the outcome. Spouses who divorce through litigation are more likely to file post-judgment applications or appeal the decision than those who came to a resolution through other processes. There's also a time concern. Litigation divorces can take several months or even years before they are finalized. There's finally an inability to come up with solutions to fit the family. Courts don't have the time or the ability to look at the specific needs for each individual family and come up with creative solutions to address those needs in making a final decision. In conclusion, choosing the process is only your first step. The next step will be determined by which process you choose. Both you and your spouse are going to need to agree on which process you believe will be best for your family. And that is why it's helpful to often meet with a neutral, like a divorce coach, to discuss your options prior to making a final decision. I want to thank you for taking the time to watch this video. This will be helpful for you during your consultation. If you have any questions as a result of this video, we can certainly go over it when we meet in your consultation. You can also reach out to our office and we will certainly try to assist you as best we can. Again, my name is Melissa Fekak and I am with South Jersey Divorce Solutions.